Welcome to Notable Approvals. I am attorney Amanda Shaffer. Before we get to our case today, don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you're watching. And if you are on Facebook or YouTube, our contact information is scrolling across the bottom of your screen. On Instagram, you can find our contact information in our bio page. And if you find this video to be helpful or know someone who may, please hit that share button or save button so you can come back to this video when you need it. So, today we got another what I like to call marathon case due to the length of time this case took to complete. Part of the reason was because of COVID. I would say a bigger part of the reason is the backlog in um, cases in the family court system in New York City. And that is something I talk a lot about the immigration court backlog, but we have a family court backlog as well here, especially after COVID. So this case began all the way back the end of 2019, so right before COVID hit. It started, parties were married, mom and dad were married, and they decided mom's family lived in Brooklyn. So they drove to Brooklyn with their, at the time, infant child. And they got to Brooklyn, and mom said to dad, I don't want you here anymore. I don't want to be with you anymore. Go back home. So dad reluctantly left. His child and wife went back to Vegas. COVID hits. He files for divorce in Vegas first, and she files here for custody, child support, and an order of protection. Now, the order of protection custody case, those in New York, those get held together. Child support gets held a separate judge altogether. So we dealt with the custody and order of protection years ago. That I think if there even was an order of protection issued, I think it was withdrawn. But if there was, it's over by now. But in this case, I represented dad. Dad was not coming to New York because he couldn't afford to come to New York. And it was really a shame what happened in the custody case. It was kind of a heartbreaker, to be honest, because of the domestic violence allegations, they always err on the side of caution because we never had a trial on the issues. They were requiring supervised visits to start. The problem is he was in Las Vegas and she was here with the baby. So to do supervised visits, he really needed to come to New York, but that was literally the time we couldn't fly places and we didn't know when it would change. Plus, he works in the casino and those even shut down. So he couldn't afford to fly back and forth. We did do supervised visits. Oh, sorry. They were technically supervised. We did FaceTime visits. Those were supposed to hopefully, kind of keep the relationship intact between father and son. But, when you have an 8-month-old or 1-year-old sitting in front of a FaceTime camera, in front of an iPad, hard to keep their attention. There was a lot of problems that we had, and whose fault, if any, we don't really know. But what we do know is that eventually my client got this took a big emotional toll on him, not being able to be with his son. And if he could come to New York to see the child, he would have also had to pay for his own housing. He probably would have had to stay for a little bit of time taking off work, which wasn't easy with the type of job that he had. So there was a lot of issues with him getting to see his child. And to be honest, I mean, yes, I'm biased. This was my client, but I don't think any of the allegations about domestic violence are true. It's ultimately I told my client we should fight this, go to trial. It's a risk, but he didn't have the emotional capacity for it, which I totally get. It's a lot to have to handle. And the fact is that there wasn't a known timeline then when he would be able to make this trip, because mom certainly wasn't going to Vegas. And, maybe in the future the child would go back and forth. That would be ideal when the child's older. But when they're a baby and the parents live far apart, it can be really hard for visitation. Um, my recommendation is, I mean, in this case, the first sign of trouble in the relationship, he was kind of kicked to the curb and she kind of put in those filings immediately. But what I would say is that the best thing you can do is at the earliest possible time where you notice something might be amiss is go and go to file something in court for, file a custody petition, file a visitation petition. Try to get your facts in front of the judge first and try to do it before somebody leaves the state you're in, because you can also ask, if you think they're a flight risk, ask the court to issue an order that prohibits them from leaving the state. In this case, I don't think my client and would have been able to anticipate. I think he was actually tricked. Um, so I don't think he would have been able to anticipate. There's not an answer to everything, and as a lawyer, it can be frustrating when you have those hard facts that you do what you can. But eventually, my client decided he's not going to fight for custody anymore. And the problem with the visitation, like I said, is he needed to go through those steps so that he could be cleared um, by CFS, Children and Family Services, or ACS, the Administration of Child Services. I don't remember which was involved. Um, he had to be cleared by them to be with the child alone, especially because it's a baby. They're even more careful. And, you know, it takes money to be able to do these things, to be able to travel back and forth. So it's just something to keep in mind. And they were married, and that didn't change anything in this case. So you want to always try to stay one step ahead in a situation like this, if you can. Um, I kind of felt with my client, don't give up, because basically he didn't need, we got a custody order, and he can always file for visitation in the future if his circumstances change and now he can afford to travel. And that would be a modification of the custody order, which you do have to show a substantial change in circumstances to change, especially since there was an agreement. But that it is a substantial change in circumstances to say, I couldn't afford this before, but I can afford it now. So, like, in terms of the travel. So, like, let's get this. He would start with, it's been a while, obviously 4 years. It's no longer, the infant is no longer an infant. It's probably speaking and everything. So dad would have to, go through a lot to bring his son back into his life, but certainly possible. And this is what we discussed, because he knew he wasn't in a position to really have regular visits at the time. And until the child got a little older, the electronic or the FaceTime visits weren't going to go so smoothly. So I do hope, for my client's sake in the future, that he, now that things have gotten better for him with his work um, life, that he'll be able to rekindle that relationship, not just for his sake, but for the child's sake. But I'm not really here to talk about the child custody case. If you have questions about child custody, as I said, feel free to contact me. And just as a reminder, Instagram, go to our bio page for our contact info. Facebook and YouTube, across the bottom of your screen, you can find our contact info there. So, why was the child support hearing so long? Well, that's because of the court system. Every time, once we realized we weren't going to settle, which we did try to settle, but mom was insistent, because at the time my client had lost his better job, and he had another job, but kind of started at the bottom of the food chain again because he switched casinos. and wasn't making the same money and getting the same hours, and they were trying to say, well, drive an Uber in the off time and this and that. So they wouldn't accept settling based on the Child Support Standards Act, which is uh, the default provision where you determine child support, which is a formula based on the percentage of income earned by both mom and dad. So, real quick overview: you take mom's income, you take dad's income, subtract taxes. There's a few other deductions. Sometimes you add on things, which is what I'll talk about shortly. And once you get that combined income, you then take 17% of the combined income. That's the total amount of child support that should be paid for the child. And then you take a percentage. So if combined income, I'm going to use real simple numbers, was $100,000 and dad made 60,000 and mom made 40,000, then you look at their prorated share. That would mean that 60% of that $17,000. So 17% of 100,000, 17,000. That's the amount based on the combined parental income that should be paid. And then who pays who? The non-custodial parent always pays the custodial parent. So mom here is a custodial parent. So let's say mom, this isn't the numbers in this case, but let's say mom made 40,000 and dad made 60 of that 100. So out of the 17,000, mom would be responsible for 40%, dad 60%, so he'd be paying mom 60% of that 70,000, and that math I can't do in my head right now, but you get the point. And if you go by the Child Support Standards Act, then as long as the judge finds that's fair and appropriate under circumstances, then that's the end of the inquiry. But if someone's saying that this person isn't working full time or they're working at a job making less money on purpose, that's when you end up having a trial, which is what happened here. The problem was that the court did not have more than a half hour, an hour at a time to give us. So we would have a half hour of trial or an hour of trial, and then 9 months later have it the second one, and then it was like, I think 9 months in between on average, these court dates. And that is actually also really difficult to litigate, because you have to take really good notes, or you're going to have to go get the transcript from the court, which you're entitled to, but they're very expensive. I had one client go to get a bunch of transcripts for an appeal, and he had 4 or 5 court dates, none of them lasting more than a half hour, and he was getting, like, prices from from the transcribers saying it was, like, thousands of dollars. So, if you're, represented by a 18B attorney, or you have someone appointed for you because you can't afford one, they can get them for free, but as a private attorney, I never can. So that's a little frustrating and a little hard to do a case, but we got through it. So let's talk about how we did that. Another difficulty that we faced due to the time that passed was that my client's job changed many times throughout the proceedings, throughout the 4 years that this case went on. And, depending on your line of work, that may be completely normal. In his case, because of COVID, that really just shook things up. So, they wanted to base the income off of what he was making in 2018, because that had been, at the time, the last taxes that were filed when the child support petition was filed. But 2018 was 2 years before COVID, and he didn't have that job anymore. And his job was a bartender. I don't know if there was more to that title, but you can make good money as a bartender, but you have to understand the industry too, which was part of what we had to do. It's not like, okay, I'm making good money at this bar. Now this bar closed, I'm gonna go get another job and I'm gonna make the same money. Especially when you're talking about a big bar, and I'm talking about casinos in Vegas. The way the culture works, and in New York we wouldn't know this necessarily, or the judges wouldn't know this necessarily they don't have the experience, you go from one hotel to another, you're starting at the bottom at the new hotel. They don't it doesn't matter if you have 30 years of experience bartending or waiting. Um, you are not getting the good shifts. You're not getting uh, as many shifts. He had this type of scheduling, which also interfered with the FaceTimes because he wouldn't even know his schedule until like a couple days before. And mom was very uh, unaccommodating when it came to changing the dates or the times of the FaceTimes. And, I that's why I thought we could have won a trial because I didn't think mom was acting in good faith here or promoting the best interest of the child by promoting the relationship between the child and the father. But again, it is up to the client if they want to settle or consent. And all I could do is tell them what my advice is and hope for the best for them. So, um, when this happens a lot because, at least in New York, um, due to the fact that the cases are taking so long that I have a lot of clients who change jobs, whether for better or for worse, and what is the effect of that on the child support order or proceedings. And that's going to depend on the facts and circumstances of the case, of course. I will tell you just very briefly that if your income drops and it is your fault, as in you quit your job or you purposely started working less hours, things like that, you're going to pay child support based on what you should be earning if you didn't voluntarily choose to earn less. If you can prove it is not your fault and that you are diligently searching for an equivalent job, then you're much more likely to have the judge not fault you for that. It doesn't preclude an upward modification in the future should you then get a better job. But for um, our purposes, for the initial custody determination, it is something that can be argued on both sides, and that you're going to have to really, and this is really important. And anytime I talk about child support cases, when there's any type of job issue, I always say this: you have to document your job search. And it's called the job diary. And what that is you say, okay, you have. I like to use an Excel Excel spreadsheet, and say, okay, here is the um, uh, each job I applied for, like the date I applied, how I applied, on website, straight, mailed in my resume, blah blah blah. Contact, as much information as you can about the job. I'm not saying all this has to be there, but you should have a lot. Things like who you contacted, the day you contacted them, um, what happened, did you get an interview? If not, why not? Maybe you weren't actually qualified for the job. If you had an interview, did you then get an offer? If you did you take it? If not, why not? And you definitely want to have a good job. Maybe they didn't pay enough. Maybe it required more travel than you thought. Maybe it really wasn't a good fit, but they were desperate. Who knows? Point is, if you don't have this and you do have a job loss, the burden is going to be on you to show it wasn't your fault and that you are diligently searching for an equivalent job. And that could be in terms of the job itself or at least with regards to uh, income. So, uh, the last hearing that we had before the final one, and this was kind of building throughout the case, as the opposing counsel was trying to make it sound like dad intentionally wasn't earning as much as he could. Some of the new facts that came into place was that dad had moved on from his old relationship and was now had a new fiance. He was waiting for this case to be over so the divorce can finish in Nevada, and he can get remarried. And while this case was pending, he had another child. And part of what he was saying was like, I don't want to work, 80 hours a week because I want to be home with my newborn. And that was tried to be used against him at the hearing, saying, well, you don't have to procreate. That was your choice. You knew you already had a baby to support. And you can have your opinions here on if that's an okay argument or not. It is not something I necessarily would make as an argument, but there's a point that to the extent of you you can't have another kid and then say, "Well, I can't support the first kid because I have a new kid." That doesn't fly. But but I do think that it was wrong to say that at least temporarily he just like someone going on paternity leave, that it wouldn't be okay for him to stay home. And mom, the fiance for the mom of baby two, she she was in school still, and taking the exam, professional exam that she needed. So it was hard for her to watch the kid while she studied, but also, I mean, they did need another income. They did need his income, so it's not like he wasn't working. So they tried to say, well, why don't you drive with an Uber when you're not, if you can't get a second bartending job? And he didn't even have a car, because he's like, I can't even afford a car right now. So there was a lot going on there. Um, this entire case, I was just waiting to cross-examine mom because we kept starting mom's direct examination, and that kept getting continued. Um, and there was a lot of animosity in this case, and mom said a lot of things that weren't true um, regarding my client, and there was a lot of discrepancies in what she was saying. So I don't remember if she had a bachelor's degree or master's, but she did have a degree of higher education. She was a writer. She was freelancing, which is basically just per diem or part time work, but she wasn't working full time. And she lived with her parents, but on her financial disclosure affidavit claimed that she paid over $1,800 a month in rent. And then she said she needed childcare full time, so she was paying $18,000 a year in childcare full time for 40 hours a week, but she wasn't working wasn't working full time, and she only claimed an income of 30,000. So if you do the math, that means after just the daycare, or I should say, let's do the rent, since that's a little more. After the rent, it left her with like $7,000, and that's before the childcare costs. And yes, if you're wondering, does dad have to contribute to childcare? Yeah, the law says that both parents have to contribute as long as it is actually needed. Um, if you want to go out to dinner with your friends and get a babysitter, dad doesn't necessarily have to pay for that unless he agrees to, or mom, and it could be, vice versa. But if you need a babysitter because you need to go to work or you're in school so that you could get a better job, then yes, both parents are going to have to contribute to that. But the question here is, how can these be your expenses? I mean, I didn't believe she was paying her parents money um, for rent. But how are you going to how are you going to survive on $7,000 a year? So either you're working more than you're saying, something's off with the expenses, or you're getting some help. And when you're getting some help, that can be imputed to your income. And the other part of this was, uh, to my knowledge, and I say to my knowledge just because I'll tell you what happened at the last hearing, which I was not there for. Uh, she never provided proof of her diligent job search. So she could say, I'm a writer, I can only get certain gigs. That's not gonna, you can have the same argument they were making towards my client. Well, go drive an Uber, go get a job at Starbucks, go do something where you're making money because you got a child to support. So, mom never produced the job diary. And even if she did, in this case, And this is true even for me. If I had a kid and, I was in a child support proceeding and I, uh, lost my job as a lawyer, I would have to show that I'm trying to get another job as a lawyer, and in the interim, I would need to probably get a second job, and if I found a lawyer job, but it was like 20 hours a week, then I would probably have to supplement the income by getting a second job, even whether it's driving an Uber or not. So it doesn't matter what profession you're in, what your level of education is. You have to you have to make you have to earn the amount that is reasonably necessary for your um, education, background, skills, and all of that. And you can't just earn less income to pay less child support. It's very important. So what did we do? Um, so I kept asking for proof that she was actually paying for the childcare because we had these receipts, handwritten receipts from the childcare, not not showing transfer from a bank account, not even saying how the money was paid, and that matters because and I have another case right now where the grandparents are paying for child care, and where they're trying to now get my client to pay towards that childcare, and the argument is it's that you know if they're paying for it, the father, because it's his parents, isn't his income isn't going towards it. It wouldn't have gone towards it if the parties were still together. So we're arguing that she shouldn't have to pay for it. Um, so as I said, my client wanted to settle in this case, and we made an offer that was rejected because mom wanted to impute income to him. And like I said, she said, why don't you get a second job? And like I was all ready to finally get this thing wrapped up. But then I have another case going on that I will definitely be talking about sometime soon because it's one of those international child abduction cases or a Hague Convention, or in this case, a non-Hague Convention case, all the way out in the middle of nowhere, Connecticut, yesterday or 2 days ago, and they scheduled it the same day of this case's trial, and I filed a motion to continue the case out there, and it was denied. Um, and that was a much more involved, difficult case. Whereas this one, I was able to prepare Aaron for the hearing. It wasn't very complicated. We simply needed to cross examine mom on why isn't she working full time? What are her real expenses? And then we had to question, and we did had to do the directive examination of dad, basically now explaining, because now fortunately he has a better job, explaining um, his hours, how much he works, what his schedule is like, how much control he has over working more hours, that type of thing. So Aaron um, heroically stepped in for me and killed it. He did a fantastic job. He was able to get the judge to impute, um, I think it was around $25,000 a year to mom. And when you have a salary of 30,000, 25,000 is a lot of money. So it's almost 50% that's being added on. And uh, dad was also less stressed because he did have a good job. So, the stress was, I'm going to get this child support order based on, like on double what I earn now. I'm not gonna be able to pay it. And then I'm gonna have problems, which is a legitimate concern. But we were very happy between last court and this court. Things had gotten much better for him. He had been promoted at work or got a new job. I don't specifically recall, but he was making more money and was able to afford support. And he was working full time now, so they couldn't bring this whole argument up about the part-time work and getting a second job. So ultimately, Dad was ordered to pay his pro rata share. We did go by the Child Support Standards Act, which does include the imputed income, and that was really the key here because it needed to be fair. Mom, this whole time it felt very one-sided because my client, we spent 3 or 4 trial dates of 30 to 45 minutes of mom testifying, without Dad being able to say anything. So it was hard for him since we didn't know, obviously, that until the other day what the outcome was going to be. And there was always a finger being pointed at Dad, making him look bad, trying to make him look bad, that he was the one not trying. He was the one not putting in all the effort. But the truth of the matter was, it was Mom. And I always tell my clients, immigration family cases, no matter what it is, at the beginning, like the day you call me for our initial consult, no matter what the facts of your case are, whenever, especially when there are children involved, that there's always, and in domestic violence cases a lot too, there's always a he said, she said. There's always if you ever heard 3 sides of the story, you know, um, your side, the other person's side, and the truth. But what I always say is the reality is that truth comes out in these cases. Either they're gonna, if it means we have to go to trial, it comes out at trial, or it comes out beforehand and it forces someone's hand to settle. And in this case, I knew that Mom wasn't working to her potential. I knew that Dad was trying everything he could to make more money. He even opened up his own business during COVID. He got a PPP loan to try to get off the ground. I think it's still going, but now that he's working more at the casino, I'm not sure where that's going. It ended up not being a major factor, but he did have to provide proof that he had been trying on that route. So the reason I say the truth will come out, and I stress that, is because it's important not to give up. My client did want to give up, and we did make an offer, but that wasn't an offer they wanted to accept. So he had to kind of just stick it out to the end. In other cases, he could have also offered a higher amount, which I wouldn't have advised. If you don't think you can pay it, you shouldn't offer to pay it. But the truth does come out. So even if it looks bad right now, if you have the right legal help and representation, then that lawyer, whether it's me or someone else, should be making sure that the other side has to prove their case and does their job. And when that happens, the truth does come out. And, as a lawyer, we sometimes have hard facts to deal with. We may have some discretion in choosing who we represent, but we don't choose the facts that come with it. And sometimes you take a case and you think one thing about the case, or you think the facts are one way, and then you learn later on that the facts are different, and that could change the whole outcome of the case. But the bottom line is that if you're telling the truth and you're being honest, you're gonna get the best outcome you can possibly get. You might not love it, but that's what that's just the way it is. But the bottom line is no one should have to pay a higher amount of child support than they can afford, because child support is something that cannot get I have a call, 1 second. Cannot get discharged in bankruptcy. I didn't realize at the time, I've been talking for so long. I do have to get going. I got a meeting. So congratulations to my client for being done. Don't forget to like us on Facebook, Instagram, YouTube. If you find this video to be helpful and know someone who may, go ahead and click that share button, save button, And we're here for you if you need representation in a family case. Um, give us a call, contact us, and we'll see you next time. Take care.